and welcome to the
Do
planning
we
board.
need a second motion?
I don't believe so.
No, I don't think
Just
so. That was,
acknowledge.
yeah.
Thank you.
Great. So Greg, so the next item on the agenda is the public hearing. We'll just read it into the record and then we'll go from there. So next on our agenda is a public hearing, first public hearing of the night. And pursuant to section 20 of chapter 20 of the Acts of 2021, in accordance with the provisions of Mass General Law. Thank you. Get rid of this. Provisions of Mass General Law 48, section 9, and the Gloucester zoning ordinance, section 1.8.6 and section 5.9.11. Gloucester Planning Board will hold a remote public hearing to consider a request for extension of the cluster development special permit issued to Kerrigan Development LLC for a 12 single-family home cluster development at 186 Concord Street, Assessors Map 248, Lot 14. So the public meeting is opened. Greg, if you want to explain the nature of the public hearing and the request, if you don't mind.
Sure. So I believe all but one board member was on the board at the time of the filing of the cluster development for a 12-unit project off of Concord Street, basically at the intersection of Concord and Bray Street. The board issued a special permit decision, which I think was appealed for a short period of time, but resolved, I think, by dismissal, and Deb can speak to that more specifically. And that decision has been recorded, understanding that this project has multiple jurisdictions that are responsible for review. There was, at the time of the application, a filing made with the Conservation Commission because of the various resource areas adjacent or on the property. They have issued a decision. That decision has been under appeal. And so under the special permit requirements within the ordinance and under the state statute, the building must commence within 2 years. It does have a sunset or an expiration on it of 2 years from the time of the issuance. And I believe Attorney Eliason will explain why they have not been able to act, and they're requesting an extension of the time to do so. It is fairly limited. It is not a review of project elements or project change or modification. There is a process for that should there need be any modification of the project. But this is a fairly narrow request on the extension of the condition of the permit that has an expiration associated with it, to extend so that there's opportunity for the applicant to utilize the special permit.
Thank you for that, Greg. I hope we didn't steal any of your thunder, Attorney Ellison, but the floor is yours.
Thank you, Mr. Chairman, and thank you, Mr. Catamatore. For the record, Deborah Ellison, Ellison Law Office, 63 Middle Street, Gloucester. I represent the property owner, Kerrigan Development LLC, and Mr. Kerrigan is a principal of the LLC, and he is on the call tonight. We're here, as Mr. Catamatore said, to request an extension of the special permit that was issued on September 20th, 2018 for a cluster development of 12 single-family homes on a 21.5-acre lot. The special permit is set to expire on July 9th, 2022, and we would like an extension of 2 years to July 9th, 2024. The only question before you is why Mr. Kerrigan has not begun the cluster development. And the answer to that is very simple. He has not begun because he has been held up by abutter appeals that have been pending since the issuance of the special permit. The first appeal was on September 25th, 2018 by Ms. Carrie Fricklin. She appealed your decision to the Land Court. And then that appeal was voluntarily dismissed on December 20th, 2018. It was dismissed with prejudice, and she waived all rights of appeal. On April 4th, 2018, Mr. Kerrigan filed an NOI for the project. And on September 20th, 2018, the Conservation Commission issued an order of condition in Mr. Kerrigan's favor. The abutters appealed that to DEP. On May 4th, 2021, DEP issued a superseding order of conditions in favor of Mr. Kerrigan again. That was again appealed to the DEP Office of Appeals and Dispute Resolution, and that's where it's still pending. Their hearing was held on December 9th, 2021. The briefing period for that hearing ends on March 11th, 2022. And at that point, the OADR has 1 month to issue a decision after the briefing period. Then it goes to the DEP commissioners for approval, and they have 6 months to approve. And that decision may then again be appealed to the court. So until these appeals are resolved, Mr. Kerrigan has no choice. He cannot begin his project. He is actively defending these appeals, and he plans to begin construction as soon as he's allowed to. He's been waiting a long time to begin construction, and he's not holding anything. You did receive a filing from Mr. Grant Clark on behalf of Preserve West Gloucester. And that filing raises issues that are irrelevant to the questions that are in front of you. It's a backdoor attempt to relitigate issues that were before you, were decided by you previously by a unanimous vote in favor of Mr. Kerrigan. They appealed your decision, as I said, to the court. They voluntarily dismissed it with prejudice and with no further right of appeal. They voluntarily gave up the right to raise these issues ever again. And now they want you to let them in the back door to relitigate issues that they have voluntarily given up. They are so-called new facts that are currently being litigated before DEP. These are not issues for the planning board. They're not before the planning board. It's not relevant to the discussion tonight. The permit was issued by the planning board after a thorough vetting. There were 3 nights of hearings from June through September in 2018. Planning board decided unanimously in favor of Mr. Kerrigan's project, and it cannot be relitigated. The legal term is called res judicata, and that means a matter that has been adjudicated cannot be pursued further by the same parties. Therefore, the testimony regarding the extension should be limited to questions related to the extension. It's not an opportunity for people to relitigate. The special permit is final, and it cannot be relitigated at this point. So I would ask the chair to limit the discussion to the relevant matters, and I'm happy to answer any questions the board may have with regard to the extension.
Thank you, Attorney Ellison. Before we get into the I know you have a little bit of a timeline here, Greg. If there's any other color that you'd like to add. Thank you.
Sorry, I'm muted. No, again, I think it is fairly limited. The board weighs the request for extension of time. There can be instances where perhaps how things have been conducted associated with construction and concerns about completion and those types of things would weigh in the amount of time that the board might extend or not extend. We are in a situation where the project hasn't been initiated and it's been presented as to why, and it's the discretion of the board to extend.
Okay, thank you. Any questions from board members before we take public comment on this? Jane?
Yeah, this is a question for Deb. So on my agenda, it says, and I'm a stickler for the ordinance, 1.8.6. So it seems to me that the issue before us is except for good cause, and that I understand that you're arguing that this is good cause to extend. But it also said on my agenda 5.9.11 future changes, and then it refers to major and minor changes in a cluster development coming back to the planning board. Are you proposing that there are any major or minor changes?
I think that was included as an abundance of caution because there was a condition in the special permit itself that spoke to the 2 years. So that was just added in for that reason.
Okay, so you're not proposing any major or minor changes?
No, just the extension for 2 years.
Thank you.
Thank you, Jane. Other questions from board members? Mr. Rosen?
Also a question for Deb. So this came in 2018. Has it been extended once already?
No, it was during the COVID state of emergency. There was a law that was passed which allowed a tolling period. And that was from March 10th 2020 to June 15th, 2021. So it was a period of 462 days that we're told. So that's the reason that it has been some time. We have not been before this board for any extensions.
Okay, thanks for clarifying that.
Other questions from members? Hearing none. So we are in a public hearing setting. So I would like to take public comment for people that are in favor of this extension. So if you're in favor of this extension, please raise your hand electronically. I don't believe we have any phone callers. So if you're in favor of speaking for the extension, we can recognize you. I ask that you state your first and last name and address for the record, and you'll have a 3-minute comment period. Again, people that are in favor. So, and Ellen Lehman is first up. Oh, disappeared. Again, anybody in favor of the extension? Okay, seeing none. So anybody that would like to speak in opposition of this extension, I'm going to ask people to be respectful of the item that's before you. Our planning director has stated the scope of the extension. This is not a reapproval of a special permit that was granted. I think Attorney Ellison laid out the details of why. So again, first and last name for the record, address, and 3 minutes will be granted. So Mr. Grant Clark, please.
So I actually have to jump off for about 10 minutes.
Yes.
Gemma, if you could recognize folks, please.
Yes.
Thanks.
Thanks, Greg.
And I'm sorry, Rick, I was just distracted for a moment.
That's
Do you mind
all right.
telling me who
Grant.
you had?
Grant Clark. Just need, there we go. Mr. Clark, the floor is yours.
Thank you. Can you hear me all right?
Yes.
Okay. Very respectfully, Attorney Ellison is entitled to her opinion.
Again, sir, just name and address for the record, please.
Grant Clark, 279 Concord Street in
Thank you.
Gloucester. Attorney Ellison is representing a developer. She's an advocate. She has the right to her opinion. She is not counsel to your board, however. I'm an attorney who's been licensed in Massachusetts since 1983. And what she is saying about res judicata is simply wrong and does not apply to these proceedings. It in no way precludes the board from considering new facts or deciding not to extend a permit if new facts dictate that that would be inappropriate. So with that introduction, I would say we have already made written submissions. You have them. Quite simply, the planning board cannot issue a special permit without approval from the Board of Health of a definitive cluster plan or a DCP. That approval has never been issued, and the special permit that resulted is, as a result, invalid. An invalid permit cannot be extended. Further, there are facts available today that do not appear to have been available in 2018. And these facts preclude the Board of Health from approving the DCP today, the definitive cluster plan today. Now, as you know, in 2018, the planning board properly went to the Board of Health for approval. And the cluster reg says that the Board of Health must approve the definitive cluster plan or DCP within 45 days. So there's 3 elements: Board of Health action, approval within 45 days. To date, there has been no action at all by the Board of Health, let alone an approval. What happened instead was that there was a series of letters from Max Schenk to the planning board. Max was then the assistant director of the health department. We have great respect for Max, but he is not the Board of Health. Further, all Max said in these letters to you was that there, quote, appeared, and I stress appeared, to be sufficient soils and space for the design of a 34-bedroom septic system. Now, the planning board apparently treated this as the approval of the BOH that was required by the cluster reg. Now, of course, the word approval never appeared anywhere in any of Max's letters. In fact, he made it pretty clear he wasn't approving anything. And of course, Max was not the proper approval authority in any event. He is not the Board of Health. And the Board of Health must act according to the governing regulations. So the original permit, I'm sorry to say, the original permit was invalid. Now, here's where it gets interesting. When Mr. Schenk sent his letters to you in 2018, he was relying on 4 test pits that had been dug by the developer. The developer said that all the test pits were good, no ledge was encountered. Now, the interesting thing is that those 4 test pits were all clustered on one side of the proposed leach field, only on one side. On the other side of the leach field, the side where no test pits were dug, the developer's own plans show exposed ledge sticking up through the ground. Further, even on the side where the supposedly clean test pits were dug, the developer's own notes show that ledge was visible on the sides of 2 of the pits. Now, as you all know, Title V requires that there be 4 feet of naturally occurring soil between the bottom of the system and the top of the bedrock. That separation cannot be achieved given the existence of this ledge sticking out through the ground and visible on the sides of the test pits. Now, the reason this is important to you and why you have every right, and in fact are obliged to consider this, is that we do not believe that Mr. Schenk had access to these facts when he wrote his letters to you. And in light of these facts, we don't believe that the Board of Health could issue a letter today saying, quote, there appear to be sufficient soils and space for the system. So, since no approval has ever been received by the Board of Health of the definitive cluster plan, the initial special permit was sadly invalid. You can't extend an invalid permit. But even if the initial permit were valid, it cannot be extended based on the facts known today, because the Board of Health cannot give you an approval of the cluster plan in light of that ledge. Thank you.
Okay, I appreciate your commentary and keeping your comments concise and within the time frame. There's somebody that's raised their hand named CLF, and I can't recognize you unless you can get your name correct on the attendees list. So if there's anybody else that would like to speak in favor while CAF or CLF can rename themselves, let's recognize Jim and Mr. McGurk.
Okay, unmuted. Good evening. My name is Dennis McGurk. I'm at 283 Concord Street. Thanks for giving us the opportunity to speak. We've learned a great deal since this proposal was introduced to the planning board almost 5 years ago. When the plan was approved, the neighborhood was shocked at the result and the process that preceded it. How could this happen? So we studied, and the more we studied, the more we learned. It just didn't make sense. This was a square peg in a round hole. More neighbors and other neighbors from around the city joined in. We studied the ordinance, we learned the details, we collected money, we went to court, and the facts became evident. The cluster ordinance was designed to maximize open space and to minimize the potential negative environmental and community impact. Simple. The ordinance states also that it must be a design that is superior to a conventional proposal in order to be approved. It's not
Mr. Chairman,
intended.
point of order. I'm sorry to interrupt, but this is off the topic for tonight.
Yes. Again, Dennis, we're talking about opposition to the extension of
That's exactly where I'm going. Can I finish, please? Because this is exactly, I think, a very good reason why you have to consider stopping the appeal. Can I just finish my couple of minutes here, please?
keep your comments at 2 minutes.
The ordinance is written as it's the design. Okay, the ordinance is written is very strong in principle, but somewhat vague in detail and open to interpretation. It was these gaps that allowed the developer to be very creative and his attorney to be very convincing. It enabled them to paint a very different picture of what a cluster could be. It enabled them to say that this cluster was superior to conventional design, when in fact they presented no such evidence. It enabled them to put 12 houses where only one could actually work. It enabled them to take 7 stated purposes of a cluster that are listed and made them look legitimate when in fact no one was viable. It enabled them to do the same with the 8 stated design criteria. What happened was these representations turned the planning board upside down. At the last public meeting on the subject, one member in her closing statement made a memorable comment that the cluster plan was the only possible way to get that many houses, 12, built on that lot. She proceeded to clearly express her belief that greater density was the objective of the cluster development. Other board members echoed their approval of her statement. The planning board had been sold a bill of goods. They had been sold a bill of goods. They were led to believe that this is what cluster design should look like. The spirit of the cluster ordinance and its intended good to build wisely, to preserve the economy, the environment, and the community around it had been destroyed by the developer and his attorney. So the permit to build 12 homes on this rocky ledge was approved. The neighborhood has since invested hundreds of hours and thousands of dollars in an attempt to prove and to bring the truth to light. 5 years down the road, we're all a lot smarter. The board now has the rare opportunity to reverse their decision, and the request to extend the permit must be denied.
Thank you, Mr. Clerk. Anybody else that has something that hasn't already been stated? So let's recognize Diane Clark. Again, Ms. Clark, we're looking for a new commentary on reasons to not extend this special permit.
Yes, I've got that. Can you hear me, Rick?
Yes.
Okay, well, Preserve West Gloucester has shown that a compliant septic system cannot be built on this site. If the developer is going to allow it in any way, and that system fails, it's not like an individual homeowner's system failing. This is a community of 12 homes, which is 34 bedrooms. The relocation of the system would be the homeowners association expense. If the HOA can't or will not relocate this entire septic system, then the city must step in and either A, relocate and build the system, or B, connect the development to the nearest city sewer. Who's going to bear this cost? The citizens? If this can't be avoided by not allowing the construction of a septic system where it obviously can't comply with Title V. Thank you.
Thank you, Ms. Clark. So Gemma, let's recognize CLF and see if we can understand who we're talking with, please.
Hello?
Yeah.
Hey, this is Carrie Fricklin. I tried to change my name, but it wouldn't
Oh, hey, Carrie.
change for some reason.
Just
Yeah,
your
so
address for the record, please.
250 Concord Street.
Thank you.
I'm a direct abutter to the 186 Concord Street property. And I believe the planning board should not extend the permit for the following reasons. 1, the current cluster plan is not the same plan that the planning board originally permitted. The original plan did not include an adequate stormwater management plan to protect the surrounding natural resources. The applicant has submitted several stormwater plans to the DEP over the past few years, which have been rejected, and his latest plan is still pending litigation. 2, it is a requirement in the Gloucester Cluster Regulations, section 5.9.5. The protection of natural features and open space should be used as the basis for the planning board's decision when considering a cluster development superiority to a conventional development. The applicant claims that they are preserving 78% of the land. The exact same land is already legally protected by the Wetlands Protection Act and Gloucester Wetlands Ordinance. The cluster development would only pollute and cause irreversible harm to this already protected land and resources. The applicant has not provided plans to date that would prove otherwise. Some of these natural resources that are now threatened include outstanding resource waters to the area of critical environmental concern, ACEC, and Great Marsh, and the largest and most prolific certified vernal pool in Cape Ann, according to Cape Ann Vernal Pool. The 186 Concord Street property has always been classified by the city as unbuildable for a good reason. Number 3, the applicant, now going into 5 years, still has not submitted a septic plan to the Board of Health. The applicant's most recent site plans show for the first time the presence of exposed ledge in the proposed leach field. In the order of conditions, the Conservation Commission expressed their heightened concerns of the large-scale septic system perched on steep ledge overhanging wetland resource areas, and were aware of the Gloucester Board of Health's concerns to the adequacy of the septic design. The Conservation Commission and PWG's hired expert, Mike Igo, both confirmed that even if a Title V compliant system could somehow be constructed on the site, it would still not ensure the absence of negative impact on site wetland resource areas. The commission and Mike Igo both stated all of these concerns before any ledge was known to be protruding in the middle of and the sides of the proposed leach field. In conclusion, the board should not extend the permit for all of the reasons given and the fact that the plans are still in flux due to the pending litigation. Thank you.
Thanks, Carrie. Anybody else like to speak against the request for extension? Okay, seeing none. I'd like to get oh, there's Jane Dobson, if you don't mind. Gemma.
Yes, I'm sorry if I go off a little bit, but I want to re-emphasize the fact that we really need out here in West Gloucester to consider water source.
Jane, can you
Yes.
state your address, please?
Oh, I'm sorry, Jane Fox Dobson, DOBSON at 14 Becker Circle, Gloucester, Mass.
I'm sorry, I didn't quite hear that. The phone was muffled.
14 Becker Circle
Thank you.
off Concord Street. In my neighborhood, again, we're up on a hill and water flows down. Our water pressure is so slow now, and it used to be better, but when they added all those homes down on Fox Hill Run, we saw a big decrease in our water supply and our pressure. And I'm just afraid with 12 more houses going downhill, we're gonna have more problems, because all of us up here on White Mountain Road and Becker Circle and Becker Lane have tremendous water pressure problems. And it's getting worse every time there's new homes being put down towards Bray Street, Marshall's Farm Stand. And I just think that we need to look at the infrastructure first before we keep allowing all this development. Right down at the end of Annie's last Saturday, there was a huge main break on Concord Street. We had no water. There's, so I just don't understand why we keep building when we can't fix the problems that we have in West Gloucester regarding water supply. And I mean, there's actually houses on my street that don't even have city water. They have well water because they can't even get, it's private road and you can't get lines up here. I just don't understand why you would accept or start allowing more building when the city hasn't fixed the problems that we have.
Okay.
Thank you.
Thank you for your comments. And I'd like to recognize Peter Rodosha.
Unmute. Hi, Pete Rodosha, 259 Concord Street, Gloucester. Our property is down the hill slope from this proposed development. And I'm not going to repeat all the things in the septic and all of those kinds of things, but I will tell you that all the water from that property flows down through our property and goes out to the Great Marsh. And we really need to be aware and cautious of what we're doing with the stormwater and also the septic. And just to follow up on the last comment, and then I'm going to get off this, I believe the houses in that development are supposed to have wells dug. I think there's 12 wells that's supposed to be there. I don't think there is town water, that development. Deb, if you can nod your head and agree to this or not, that would be helpful. Okay, yeah. So they're wells. And what we have seen is, again, 12 wells being dug in that area is going to affect the groundwater in all the other areas where everybody else has wells. And again, you're putting a large concentration of 12 dug wells into a small area, which is going to change the water flow, of which a lot of the houses, including ours, is on well water. I can't even get city water. So again, I really think that people need to really consider what's going on up there, what's really the case. It's really a shame as to what documents were not presented at the time to the planning board, so they could have made a really knowledgeable decision based on the information about the property that's really going up there. So thank you again, Pete Rodosha, 259.
Let me just, Peter, if I can just ask you a question. Do you know what your recovery rate is on your well?
We are producing 25 gallons a minute, I believe.
So that's terrific.
Yeah, we've got good flow right now, and I'd like it to stay that way, because if it is slow, we're gonna have a really big problem.
Yeah, no, I'm curious. I just dug a well too, so I'm painfully aware of that number. Thank you.
You're welcome.
Okay, anybody else that'd like to speak against the extension of this cluster special permit? Okay, seeing none, I'd like to turn the floor over to Attorney Ellison to answer some of the, I can just call them questions as being polite.
Mr. Chairman, I think it's important again to reiterate that this permit is final. It was appealed and they voluntarily dismissed that appeal. So it's not an invalid permit. It was certified by the city clerk and it's been recorded at the Registry of Deeds. It is final. If you want me to go into detail and answer some of these questions, I can, but these are really all issues that have nothing to do with what we're doing here tonight.
Okay.
They were all discussed in 2018. We had long meetings and all of these issues were raised, as all of the board members who were there, I'm sure, remember. There's no ledge where the septic is, that's a boulder. I would like to point out that Mr. Clark is not an active attorney. His license is inactive, and so he is not practicing at the moment. DEP approved the superseding order. They looked at all the plans, they looked at the stormwater, they looked at all of that, and they approved it all. So I would suggest to you that this has all been thoroughly vetted. Any issues that are still out there are currently before DEP, and that is the body that will be deciding those issues. And to date, we have had positive, favorable decisions from both the Conservation Commission as well as DEP, and we expect that to continue. So if you do want me to answer some of these questions that I would suggest are irrelevant, I'm happy to do so. But I would prefer that we go ahead with the extension discussion.
I would concur. I'd like to recognize an Anne Marie before we close the public comment period. And Anne Marie, I just need to have your first and last name and your address for the record.
Actually, this is her husband, Jerry Torella,
Oh, hi, Jerry.
127 Bray Street. How you doing tonight?
Good. Thank
I
you.
guess I just got one question that I've been listening to, and maybe Deb can answer this. Did the Department of Health approve the septic system? Yes or no? And if
Sir,
the answer is no,
Sir,
then
this
yes.
is, that's not in order. So the discussion is the reasons that you're gonna,
Yeah, should the permit be extended?
But
If the Board of Health didn't approve the septic system, then is the permit even valid to extend? That's all I want to learn.
Okay, thank you for your comments.
Do I get an answer?
It's not the purview of the planning board to discuss a conditioned approval by another board.
But you approved something without getting the approval from the Department of Health, which from what I understood from the first person who spoke, the attorney, he said that in order to get the permit approved, the Department of Health would have had to have approved the septic system. So isn't this whole conversation based on the septic system, whether or not one could even be put there? I mean, it seems pretty simple and straightforward for this whole conversation. It's all based around the septic system. If the septic system doesn't get approved, then why are we even going down this road all these years?
So
Shouldn't
respectfully,
we ask the Board of Health, are you going to approve it? Because if the answer is no, then I guess we all have our answer.
so the Board of Health needs an opportunity to approve or not approve the septic.
So
And
can you
it's
tell me why
conditioned-
that wasn't done in 3 years?
Sir, I don't control the Board of Health. They have their own standards. This special permit, which was approved, and you've heard from the attorney that it's a final approval based on conditions. If those conditions aren't met, the special permit and building permits will not be issued. And the applicant has every right to seek the appropriate approvals and make the changes to move forward with the project. If they can't do that, then they don't get a building permit. It's
Right,
as
I'm just
simple as that.
confused though, after all these years that the Board of Health hasn't had an opportunity to look at the septic design and say yes or no.
Well,
You
that's
know, it
not
just
for me to
seems-
say, right? And so what's before us tonight is an extension discussion. I'm not the Board of Health. And I am going to end the conversation with you here and let two other people that, or at least one other person that hasn't had a chance to speak. So but thank you for your comments. Let's recognize Gail Gould, please, Emma. And just name and address for the record, please. You're muted. Gemma, can you help with the unmuting?
I just asked to unmute and I think oh, no. I think he might have just hopped off.
Okay, maybe he's trying to reboot. We'll give him a second.
It's Gail Guiled, and it's
Guiled?
she.
Okay, got it, yeah.
While we're waiting,
Mhm.
I'd just like to make a comment that until a court of law tells us that our special permit is not valid, it's valid. And that's what's before us tonight.
Correct.
So rehashing how the special permit got approved isn't going to help us here at all.
Understood.
Mr. Chairman, I can answer the question with regard to the Board of Health if you'd like also. There
Oh,
was,
oh.
as you may recall, that there was an approval by the Board of Health that was filed with your board for cluster development purposes. My client cannot file his septic design plan with the Board of Health until these appeals are resolved. That's what's holding it up.
Yeah.
So he's waiting for the appeals to be resolved, and then he'll be able to move forward on any other permits that are required.
Right, that's my understanding.
It looks like Gail left the meeting.
Okay. In the spirit of full disclosure, I'd like to allow Mr. Grant to speak for a second time. Again, Mr. Grant Clark, if we could keep our comments brief, extension as a courtesy. The floor is yours, sir.
Yeah, yes, thank you, Mr. Noonan. Can you hear me all right?
Yes.
Thank you. It really does raise an interesting question. Would the board, if the developer's site had been declared to be a Superfund site requiring a federal environmental cleanup, would the planning board take the position, well, you know, a court hasn't told us that the permit's no good, so we really can't do anything about it. We have to extend it. I think the logical answer is no. There are all kinds of events that happen in the course of a project like this, particularly where there's parallel litigation going on, where facts are being disclosed all the time, that the planning board is not obliged to turn a blind eye to those new facts and is not obliged to simply blindly extend a permit when it has not received, there is no evidence in any record that we've seen at any proceeding of the planning board that the Board of Health, the 4 members of the Board of Health, back in 2018 or today, gave an approval of the definitive cluster plan as required by the regulation. So I
Mr. Clark,
don't,
you're on record of already saying that. So if you have anything other comments, I mean, this is a second bite at the apple for you. So if you had something else, you get 30 seconds to respond and then.
nope, I think you know our position. Thank you.
Okay, fair enough. So I'm inclined to close the public comment period unless there's somebody else that hasn't spoken. Okay, so we're going to close the public comment period on this extension request. Discussion among our board members, please. Okay, hearing none. Jane, would you like to make a crack at an affirmative?
Nope.
Sorry,
Since no
Beverly.
one else is, I
Okay, go ahead,
always
Beverly.
hate to be the first one, but this has been a very, very controversial issue, probably the most controversial that I've encountered in my 3.5 years on the board. And we heard testimony over several days. Some that were just public meetings, some were actually public hearings. And we reviewed this in great detail against the requirements in the code. The city, under state law, has very, very robust requirements for both stormwater and for septic system design. And we had no reason and have no reason at this point to not accept our city engineers' approval of those under local and state rules. And we have a situation here where our neighbors who have their right have appealed. Their appeals have had no traction, and they have delayed the project for 2 years seeking their appeals because our applicant could not go forward until these are resolved, obviously. And so it seems only reasonable and fair to extend the approval for 2 years, and all during the time that the formal and final construction plans are submitted. During construction, all of the requirements for stormwater and stormwater runoff will be checked periodically by the city to ensure compliance with the construction plans as approved. And it just seems to me that there are absolutely no grounds in this case to deny the applicant an extension of 2 years.
Thank you, Beverly. Any other comments from board members? Hearing none. Do you want to take a crack at a motion, Jane?
Yep. I just want to say that according to section 1.8.6, I believe the applicant, due to the appeals process, qualifies for the phrase "good cause" found by the special permit granting authority. Therefore, I make a motion that we grant an extension of 2 years. Is that correct, Deb? Yep. For the cluster development special permit issued to Kerrigan Development at 186 Concord Street, Assessor's Map 248, Lot 14.
You would, with all due respect, insert the 2 years of July 9th, 2024.
2 years as of July 9th, 2020. Oh, sorry, to July 9th, 2024.
Correct.
Because the original special permit expires in July of 2022. Thank you.
Thank you.
So we have
Second.
a motion
Second.
and Beverly seconds. Any further discussion? Hearing none, roll call vote, please, Mr. Catamatore.
Member Noonan,
Yes.
member McCarl,
Yes.
member Bookin,
Yes.
member Cook,
Yes.
Member Henry,
Yes.
Member Remsen,
Yes.
Member Rosen.
Yes.
Unanimous vote. Thank you very much.
Thank you very much.
So next on the agenda this evening is a continued public hearing pursuant to Section 20 of Chapter 20 of the Acts of 2021 in accordance with the provisions of Mass General Law 40A, Section 9, Mass General Law 40, Chapter 41, Gloucester zoning ordinance, and Section 5.9, cluster development, and the rules and regulations governing the subdivision of land in Gloucester. Gloucester Planning Board will hold a